You might be frustrated if you get caught in traffic on your way to work, even though a traffic jam at rush hour is entirely foreseeable. But would your frustration excuse you from going into the office for the day? In Adbar LC versus New Beginning C-Star, we explore whether a party's contractual performance may be excused under the doctrine of commercial frustration if the frustrating event was foreseeable. New Beginning C-Star, which provided drug and alcohol rehabilitation services, was interested in moving to a new location. Accordingly, it entered into negotiations to lease property in the city of St. Louis from Adbar LC. New Beginnings received a preliminary indication from the city zoning administrator that its proposed use of the property was allowed under applicable zoning regulations. Accordingly, New Beginnings entered into a 3-year lease with Adbar. Freeman Bosley Sr. was the alderman for the ward where the leased property was located. Bosley embarked on a campaign to prevent New Beginnings from relocating to his ward. Bosley's efforts made it difficult for New Beginnings to secure an occupancy permit. Eventually, however, New Beginnings received an occupancy permit for its new facility. Bosley then contacted the chairwoman of the committee responsible for New Beginnings state funding and demanded that she pull New Beginnings funding. Thereafter, New Beginnings claimed that the director of Missouri's Division of Alcohol and Drug Abuse threatened to pull its funding if it moved to its new facility. Ultimately, New Beginnings opted not to move into Adbar's property. Adbar sued New Beginnings for breach of the lease. New Beginnings asserted that its performance was excused under the doctrine of commercial frustration. The trial court ruled in New Beginnings' favor. Adbar appealed to the Missouri Court of Appeals.